There is a specific kind of silence that fills a hearing room when a witness realizes the next sentence will cost them something. Not the ordinary pause before a prepared answer. Not the practiced hesitation of a veteran official buying time to choose careful words. Something different, the kind of stillness that follows when a document appears on a table and the person being questioned recognizes exactly what it means. That silence arrived in that hearing room the moment Joe Neguse placed a single printed page in front of the cameras and read one line aloud. He did not shout. He did not perform. He did not deliver a speech designed for television clips. He asked one question, a precise question, a question that had been constructed from months of documented evidence, public records, and a timeline that moved in only one direction. And Pam Bondi, the Attorney General of the United States, the most powerful law enforcement official in the country, did not answer it. What followed was not political theater. It was not a partisan confrontation dressed up as oversight. What unfolded in that chamber was something closer to a structured examination of the record. And the record, once laid out in sequence, told a story that no prepared statement could neutralize. This is that story. Understand first what Joe Neguse is and what he is not. He is not a prosecutor. He does not carry subpoena power into that hearing room in the same way a federal attorney carries authority into a courtroom. He is a member of Congress, seated on an oversight committee, operating within a defined procedural framework with limited time and limited tools. What he has, and what he used with precision that morning, is the ability to place documented reality next to stated position and let the distance between them become the argument. He is also a lawyer. Not a former lawyer in the way many politicians claim the credential as a biographical footnote. A working legal mind trained to read documents not as political objects but as structural evidence. Trained to understand what a signature means on a directive. Trained to understand what an omission means in a record. Trained to understand what silence means when a direct question lands in front of a witness who has no clean answer. When Neguse walked into that room, he carried none of the theatrical equipment that congressional hearings often depend on. No thick binders stacked for visual effect. No dramatic opening monologue rehearsed for maximum broadcast impact. He carried a reading of the timeline so precise, so narrow, so surgically targeted that the Attorney General had no procedural room to maneuver. That is what a corner looks like when it is built not from accusation but from documentation. Begin with what was already established before Neguse ever spoke. The Epstein files had been released. That was the public representation. That was the institutional claim. The Department of Justice had conducted a review, produced a public database, and presented it to the American people as a complete accounting of what existed. The word complete was the problem. Because complete is not a subjective standard. Complete is a number. It is a count that either matches another count or it does not. And when the public database was placed next to the Maxwell trial discovery log, a court-supervised record compiled under judicial authority and locked into a criminal case that resulted in a conviction, the number did not match. The court record showed 15. The public database showed 7. 8 records unaccounted for, not misplaced, not pending, not under a separate review with a documented timeline for inclusion. Gone from the version the public was allowed to see. 3 of those missing records were FD 302 reports. That designation matters more than any other detail in this sequence. An FD 302 is not an administrative summary. It is not a cover sheet. It is the official record of an FBI witness interview. Every statement documented line by line. Every detail preserved in the form it was given at the moment it was captured. Every reference noted. Once it enters a federal case, it becomes part of the evidentiary structure. It cannot be casually removed. Its absence from the public record is not a filing error. It is a documented gap with a documented cause. And the cause, as established by a Department of Justice internal notation dated January 14, was an expedited classification review ordered with a specific scope and a specific deadline. Scope: all Epstein-related witness interviews referencing current or former senior government officials. Deadline: completion before the scheduled public release on January 28. Those 3 FD 302 reports fell directly inside that scope. They were identified during that review. They were not included in the release. And 14 days after a formal congressional request for the full work product of that review, no complete production arrived. That was the landscape before Neguse spoke. A verified gap, a documented directive, an unexplained removal, a formal request without a complete response. Now watch what Neguse does with that landscape. He does not enter it from the top. He does not begin with the conclusion and work backward. He enters it from the edge, from the single point where the documented record and the stated position of the Department of Justice touch each other and do not align. He does not ask whether the documents were important. That question invites debate about interpretation and significance. He does not ask whether the review was legally authorized. That question invites a recitation of procedural frameworks that can be described indefinitely without resolution. He asks something narrower. He asks about one specific document, one specific authorization, one specific decision that connects a named official to a specific outcome in a traceable sequence. The question is not complicated when you hear it stated plainly. It is, in fact, the simplest possible version of the larger accountability problem the hearing had been circling for weeks. If you authorized the classification review, and the classification review removed these records, and those records were then absent when sworn testimony stated no evidence existed, what is the legal basis for that sequence? Not the political basis, not the institutional basis, the legal basis. That question does not have a comfortable answer. It does not have a prepared answer. It does not have an answer that can be delivered in the language of appropriate channels or complex legal considerations without the absence of specificity becoming its own form of testimony. What Pam Bondi understood the moment that question was asked, what her attorneys understood, what every lawyer in that room understood, was that the question was structured to eliminate the usual escape routes. Officials answering difficult questions in congressional hearings typically operate with three tools: complexity, process, and time. Complexity. The matter involves legal considerations that cannot be simplified for a public setting. Process. The appropriate channels for addressing this concern are not a congressional hearing but an internal review mechanism. Time. The question requires access to documents and information that is not immediately available at this table. Neguse's question closed all three exits simultaneously. It was not asking for a legal opinion on the entire Epstein file architecture. It was asking about one decision, one date, one document that was already in the congressional record. The complexity shield was unavailable. It was not asking the Attorney General to step outside her institutional role. It was asking her to account for an action she or her office had already taken. The process shield was unavailable. It was not asking her to recall information from memory. The document was on the screen. The date was on the document. The scope was written in the language of the directive itself. The time shield was unavailable. All that remained was the answer, or the absence of it. Before the answer came, or rather before the absence of the answer became visible, there was a moment that every journalist in the room would later describe in the same terms. The stillness, not silence in the theatrical sense. Not a dramatic pause for rhetorical effect. A genuine, unmanaged stillness that appeared in the gap between a question and the realization that the witness had no clean path forward. Her hands were on the table. Flat, controlled. The posture of someone who understood that any visible adjustment, any shift toward counsel, any glance away from the microphone, would be captured by the cameras and interpreted. The lead attorney seated beside her leaned forward slightly. Not dramatically. A small movement. The kind that happens when a lawyer instinctively reaches toward a client who is about to walk into a space the lawyer cannot follow. Because a lawyer cannot answer the question for the client, the Attorney General had to speak. And what she said, and more importantly what she did not say, became the defining moment of the hearing. She said that the Department of Justice handles classification matters through appropriate internal review processes in accordance with established legal frameworks. She did not name the legal authority that permitted the removal of court-verified evidence before public disclosure. She did not explain what claims the affected documents addressed. She did not provide a timeline placing her awareness of the review before or after the documents were removed. She did not address the gap between 15 and 7. She did not address the 3 FD 302 reports by name. She described a process. She did not describe what that process produced or why it produced it. Neguse did not interrupt her. He did not redirect her. He waited until the answer finished and then he did the one thing that the absence of specificity could not survive. He read the question again. Word for word. That repetition is a legal technique. It is not rhetorical. It is not aggressive. It is the acknowledgement that an answer has been given and that the answer did not address what was asked. When a question is repeated in a congressional hearing without elevation of tone and without additional framing, it communicates something precise. The first answer is now part of the record and it does not answer the question. The witness is being given a second opportunity not out of courtesy but out of procedure. What follows will also be part of the record. Pam Bondi understood this. Her attorneys understood this. Everyone in the room understood this. And the second answer was structurally identical to the first. Appropriate channels, established frameworks, complex legal considerations that cannot be reduced to a single moment in a hearing room. No legal authority named, no timeline provided, no accounting for the numerical gap, no explanation of what the three missing FD 302 reports contained or why they fell outside the scope of public disclosure after the Maxwell trial record had already verified their existence. That structural repetition, a specific question answered twice with general process language, is not simply a political non-answer. In the context of congressional oversight, it creates a documented record of a specific kind. A record that shows a direct question about a specific legal authority was posed to the official responsible for that authority and was not answered with specificity on two separate occasions in a formal proceeding. That record does not expire. It does not fade. It sits inside the congressional transcript where it can be cited, referenced, and built upon. Now consider the full weight of what was not said. The Attorney General did not claim that the three FD 302 reports were irrelevant to the investigation. She did not argue that they were properly withheld under a specific classified designation that she could name. She did not state that they would be produced through a separate channel within a defined timeline. She did not contest the numerical discrepancy between 15 and 7. She did not explain what legal entity was protected by the attorney-client privilege designation that sealed the January documents. Every one of those statements, if she could have made it, would have been an answer. Not necessarily a complete answer. Not necessarily a satisfying answer. But a specific answer that advanced the record. None of them came. And when a witness who holds the legal authority and institutional access to address a documented discrepancy declines to address it with specificity on two consecutive direct questions, the absence becomes its own evidentiary fact. Not proof of anything beyond the absence itself, but a documented, traceable, formally recorded absence that now sits adjacent to every other absence in this sequence. The missing records, the unexplained removal, the unanswered formal request, the unidentified legal authority, the unnamed client behind the privilege designation. Each absence connects to the next. Each one documented, each one sitting inside a record that cannot be retroactively edited. Step back from the individual exchange and look at the architecture of what Neguse built in that room. He entered the hearing with a defined evidentiary structure already in place. The Maxwell trial discovery log establishing 15 documents. The public database showing 7. The January 14th directive establishing the review. The scope of that review establishing which documents it targeted. The timeline establishing when the removal occurred relative to when sworn testimony was delivered. He did not need to prove anything new. The structure was already built. What he needed to do was place the official responsible for that structure in direct proximity to the specific point where the structure fails to align with the stated public position. He did that with one question. The question itself was the corner. Not the documents, not the timeline, not the numerical discrepancy. The question, which required a specific legal authority to be named and could not be answered without naming one or declining to answer, was the structural endpoint. And an official who declines to identify the legal basis for a decision she made in her official capacity, when asked directly in a formal proceeding, has not defended the decision. She has confirmed that the decision was made while declining to account for it. That is not a political conclusion. It is a procedural one. And procedural conclusions in congressional records carry weight that extends far beyond the moment they're created. There is a specific question that now sits at the center of everything this hearing exposed. Not a broad question about institutional accountability. Not a general question about the Epstein files as a political issue. A specific question with a specific answer that either exists or does not. What is the legal authority under which 3 court-verified FBI witness interview records were removed from a public disclosure database after being identified in an expedited classification review conducted under a deadline that preceded the release? That question requires a citation, not a philosophy. Not a process description, a specific legal instrument, a statute, an executive order, a defined classification authority with a defined scope that encompasses the precise action that was taken. That citation either exists or it does not. If it exists, it can be produced. It can be placed in the record. It can be evaluated against the action it purports to authorize. The gap between 15 and 7 can be explained in terms that are measurable and reviewable. If it does not exist, or if the action taken exceeded the scope of the authority it relied upon, then the question becomes something more serious than an oversight gap. Because removing court-verified evidence from a public record before sworn testimony is delivered is not a procedural technicality. It is an action with a specific legal character. And that character is determined not by the institutional seniority of whoever authorized it but by whether the action fell within the legal authority that governs it. Neguse did not accuse. He did not speculate. He placed the question at the exact point where the action and the legal framework that governs it are required to meet. And the Attorney General declined to describe that meeting point. Consider what the public now knows as a result of this hearing sequence. 15 FBI documents exist in the Maxwell trial discovery record for a specific witness. That is confirmed by a court-supervised record compiled under judicial authority as part of a criminal case resulting in a conviction. 7 of those documents appear in the Public Department of Justice database. That is confirmed by the database itself. 8 documents are absent from the public record without a complete explanation. That is confirmed by the numerical comparison. 3 of the absent documents are FD 302 reports documenting specific witness testimony. That is confirmed by the Maxwell trial record. An expedited classification review was initiated on January 14 with a scope targeting precisely the category of documents these reports represent. That is confirmed by a Department of Justice internal notation entered into the congressional record. The review was completed before the January 28 public release. That is confirmed by the timeline. The 3 FD 302 reports were not included in the release. That is confirmed by their absence from the public database. A sworn statement declaring no evidence existed was delivered on February 11. That is confirmed by the hearing transcript. A formal congressional request for the full work product of the January 14 review received no complete production within the standard 14-day response window. That is confirmed by the absence of that production. A direct question about the legal authority governing the removal of those documents was posed twice to the Attorney General in a formal proceeding and was not answered with specificity on either occasion. That is confirmed by the hearing transcript. None of those facts are contested. None of them depend on interpretation. They are the documented structure of a specific sequence that connects a classification review to a public disclosure to a sworn statement to an unanswered question. And that structure now exists permanently in the congressional record where it cannot be ignored, edited, or quietly walked back. Return one final time to the question Neguse asked. Not because the answer changes anything that has already been documented, but because the question itself illustrates something important about how accountability actually works in a system that claims to be governed by law. The question was not designed to embarrass. It was not designed to generate a clip for political broadcast. It was designed to identify the specific legal boundary that either justifies or cannot justify an action that a senior official took in her official capacity. That design is the product of a lawyer reading a structure that does not align and identifying the single point where the misalignment is most clearly exposed. One question, one point of non-alignment, one place where the system either produces a specific legal citation or acknowledges that it cannot. The Attorney General did not produce the citation. She did not acknowledge that she could not. She described a process in general terms and waited for the clock to run. And the clock did run. Congressional hearings operate on time limits and procedures. Neguse's time expired. The hearing moved forward. The Attorney General left the room without having answered the question. But the question did not leave with the clock. It is in the record. With a date. With 2 consecutive non-answers. With the full documented context that preceded it and the full absence of documentation that followed it. Patterns like that do not resolve themselves through institutional inertia. They resolve through one of 2 mechanisms. A specific legal authority is identified and produced that demonstrates the action was within its boundaries. Or the absence of that authority becomes the answer. The 14-day window for the January 14 work product has already closed without complete production. The question Neguse asked is still waiting for its citation. And until that citation arrives, every statement built on the absence of those 3 documents carries the weight of that missing answer. Not as rhetoric, not as politics, as a documented gap in a public record that belongs not to any agency or official or institution but to the people those institutions claim to serve. That is what one question can do when it is built from the right documents, aimed at the right point, and delivered without raising a voice. The corner was not built in that hearing room. It was built in the record. Neguse simply showed her where she was standing.